Tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems. You square that with Brown v. Board of Education.
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a
Can you turn your microphone?
All right, folks. Today we got something very interesting to chew on. We're taking a look at Senator John Kennedy's questioning of a couple of judicial nominees. And let me tell you, the interaction was eye-opening. Kennedy asked some pointed, simple, but powerful questions about the Constitution, the rational basis test, and even about the historic Brown versus Board decision. And let me tell you right now, if you want to see where the cracks are in our judicial system, and how nominees are trained, how they're coached, and what they actually believe about our founding documents, this hearing is a perfect case study. So let's break it down.
Judge, what is the rational basis test?
Senator, I believe the rational basis test is going to be one of your least stringent tests, and whether a law has a rational basis for the outcome intended or the governmental interest that you're trying to obtain.
Okay. What if the legislature or the Congress, as the case may be, doesn't list a reason? What if they just pass the statute?
Senator, I would submit that probably happens many times, and I think it's the role of the court when determining such matters as a definition. I think it's the role of the court to determine whether the usage of that statute, using its wording in plain meaning, whether the usage of that statute is going to reach the governmental interest that you hope is obvious, but sometimes you have to determine.
So you just create the basis, the reason for the statute?
I don't think that you create it, Senator, but I don't think that most statutes, to be honest, I don't think that they tell you what they are trying to accomplish so much as they say, this is the law. For example, possession of a narcotic. It's going to say it's illegal to possess this. We determine if there's a rational basis that forwards the ends of the governmental interest.
Well, how do you determine if there's a rational basis? Do you look at the statute or do you look behind the statute?
Well, I think that you always look at the statute. Now, I think you also look at any other precedent or case law that has interpreted the statute. However, you look to the language of the statute to determine what it does and what effect that might have.
Okay. Counselor, let's suppose that a legislature passes a statute that says if you have a college degree or a more advanced degree, you don't have to take a driver's license test. And let's suppose that assume for a second that the federal court has jurisdiction over a challenge to the constitutionality of that test, of that statute, rather. What test are you going to apply, Counselor?
Senator, that would be a classification that doesn't turn on any sort of protected characteristic, and so it would be a rational basis test that would apply in that instance.
You don't see any suspect classification?
No, Senator.
You don't see any fundamental right?
No, Senator.
Okay, what if the legislature didn't provide, so you would use the rational basis test?
I would, Senator.
And you would uphold that statute?
I think there could be some rational basis that a court could conceive of to justify that statute, and rational basis is not.
So you would invent the rational basis, the reason for the statute?
That's generally how the test has been applied by the Supreme Court and by lower courts, and as a district court judge, I would be bound by that Supreme Court precedent.
Okay. Judge, Tell me the difference, sir, between notice pleading and fact pleading.
Notice pleading, of course, goes to your due process issues under the 14th Amendment.
But what's the difference between notice pleading and fact pleading? We use two systems
Yes,
in
sir.
America, as you know.
Yes, sir. Notice pleading is based on, of course, that goes into your jurisdiction, your personal jurisdiction, and then the fact pleading, of course, goes into your subject matter jurisdiction.
What system does the federal judiciary use, notice or fact?
No, fact.
Okay. Judge, I'm about out of time. Can I have 30 more seconds, Madam Chair? You heard me talk to the nominee for the Third Circuit about how she would interpret the Constitution, and she said that the Constitution should be interpreted according to its meaning as understood by the people in America at the time the Constitution was passed. Do you agree with that?
I do, Senator.
Okay. Let me ask you what I asked her. How do you square that with Brown v. Board of Education?
I would adopt a lot of what she said, actually. I believe the 14th Amendment, as it came in, addressed.
14th Amendment was later.
It was later. It was a
Can you turn your microphone on, please?
Sorry
Thank
about
you.
that. I believe the Brown versus Board of Education is correctly decided.
I do too, but when my friends, and I'm a textualist as well, but when my friends say, well, we have to interpret the Constitution in accordance with the way the average American viewed the Constitution at the time. I say, okay, that seems fair to me. Do you think that the average American at that time looked at the Constitution and supported and believed that it provided for racially integrated schools? Do you think that was a majority view at the time?
Senator, all I know is that Brown versus Board of Education is good law, and it was correctly decided.
And why do you think it was correctly decided? I agree with you, but why?
Well,
If you interpret the Constitution by looking at its public meaning at the time.
separate was not, it was inherently unequal, not equal. And
It was what?
I just don't believe that there's any appetite in this country for any type of de jure type of segregation. I believe
At the
that
time
case-
the Constitution was passed?
I'm talking about right now. I believe that it's good
No,
law,
but
Senator.
okay. I've gone way, way over. I'm sorry, Counselor, I didn't get to you.
No problem, Senator.
So Senator Kennedy starts off with a softball. What is the rational basis test? Now, folks, if you don't know the rational basis test, here's the short version. It's the lowest level of judicial review, meaning when a court looks at a law and asks, does this law make any sense at all? Could any rational reason exist for it? If the answer is yes, the law stands. Simple as that. Now, the nominee gives kind of a wandering answer, something about it being not the most stringent, the court looking at the statute's plain meaning, yada yada. But here's the kicker. When Kennedy pushes and says, well, what if the legislature doesn't give a reason for passing the law? The nominee basically admits that courts just make up a reason. That's right. Courts don't require lawmakers to actually justify or prove why a law is necessary. They just invent a rationale to keep it alive. And folks, that right there is why government has ballooned in size over the last 100 years. Because as long as some judge can imagine a reason for a law, whether it's firearms restrictions, heavy regulations, or social engineering projects, those laws stay on the books. It gives government every advantage, and it ties the hands of the people. Kennedy then throws out this hypothetical. Imagine a law that says if you have a college degree, you don't have to take a driver's license test. Now, think about how absurd that is. What does owning a degree have to do with knowing how to drive a car? Absolutely nothing. An English major fresh out of college doesn't magically know how to parallel park a pickup truck. But the nominee responds that rational basis would apply, meaning the court wouldn't strike the law down unless it's totally arbitrary with no possible justification. And the nominee basically admits that, as the judge, they'd be allowed to dream up some kind of reason to protect the law. This is the exact problem with modern judicial thinking. Judges aren't supposed to act like creative writers, inventing reasons to justify nonsense laws. They're supposed to be referees calling balls and strikes. Nothing more. Now here's where it gets a little embarrassing. Kennedy asked about the difference between notice pleading and fact pleading. These are basic terms. Every first-year law student should nail this question. And what does the nominee say? They start rambling about personal jurisdiction and subject matter jurisdiction, completely mixing it up. Then, to top it off, the nominee flatly says that the federal courts use fact pleading. That's dead wrong. The federal rules of civil procedure are built on notice pleading. If a judge doesn't know that, how on earth are they ready to sit on a federal bench? This is concerning. Now here comes the meat of it. Senator Kennedy asks about originalism. He poses this big challenge. How do you reconcile interpreting the Constitution according to its original public meaning with Brown versus Board of Education, the landmark case that struck down segregation? This is where originalists usually get put on the defensive. Because let's be honest, in 1868, when the 14th Amendment was passed, did average Americans believe it meant integrated schools? Probably not. But here's my take as a patriot and a constitutionalist. The text of the 14th Amendment says equal protection of the laws. That phrase doesn't change based on what the loudest voices in 1868 thought. It's the principle that matters, and the principle is timeless. Segregation plainly violates equal protection. So Brown versus Board was correctly decided because the text demands equality under the law. The problem is these nominees didn't want to go there. Instead, they tiptoed, dodged, and gave weak answers about there being no appetite for segregation today. Well, of course, there isn't. But that's not the legal answer. The legal answer should have been, the Constitution itself forbids unequal treatment, now and forever. Period. Here's the bottom line. We need judges who know the Constitution, judges who can clearly articulate why they believe what they believe, and judges who won't bend over backwards to justify every crazy law politicians pass. Senator Kennedy does something smart here. He asks simple questions. Because if a nominee can't explain the basics clearly, or if they can't defend their constitutional philosophy when pressured, then what faith can we have in them when they're wearing a black robe on the bench? Too often, judges hide behind vagueness, trying not to offend anyone. But the people deserve clarity. They deserve judges who will stand on principle, not just punt to precedent or invent justifications out of thin air. And as patriots, we need to hold the line. Because the Constitution, the greatest governing document ever written, was meant to restrain government power, not rubber stamp it. That's my take, folks. Senator Kennedy exposed some real weaknesses in these nominees. But he also reminded us what's at stake. The way judges think about the law shapes our freedom for generations. Drop me a comment below. Do you think these nominees sounded ready to sit on the bench? Or do you think, like me, that maybe we've lowered the bar too much for lifetime appointments? Until next time, stay strong, stay free, and God bless America.